have an eminent panel. All of their CVs and details are there in the brochure in front of you. We're going to be dealing with a topic which is one of the most controversial. It's a topic that has become extremely important in common day commercial reality. Gone are the days where most contracts had two parties. Today you have complex, multi-party, multi-contract, multi-layer transactions. There are group companies that are involved. There is construction contracts, back-to-back, subcontractor related things. So the issue of joinder of non-signatories or non-signatories to arbitration agreement comes up fairly frequently. What we'll try and do is over the course of next 60 minutes, give or take a few, we're going to discuss how courts in various places have looked at this issue. We're going to discuss how arbitrators deal with these things, and we'll also talk about how arbitral institutions have responded to the need for joinder. But let me start with something that I read as I was preparing for this. In an article by Professor William Park in 2009, he started with one line and he said, like consummated romance, arbitration rests on consent. So consent is most important, but what we are doing when we are making a non-signatory a party to the arbitration agreement, we are going beyond consent, or we are trying to create consent. So what we'll do in this first part, I'm going to ask Ashish first and then Toby to talk about these two principles just as an introduction to this topic of non-signatories and arbitration agreements. I'll ask Ashish to tell us briefly when this issue of joinder of non-signatories comes by in the context of implied consent, and then maybe to Toby, where briefly he can talk about the concept of disregarding corporate personality, group companies, just as an introduction to extension of arbitration agreement to non-signatories. Ashish, first you, then we'll move to Toby.
Thanks, Ankit. I think implied consent is a very debatable and an interesting topic, and I think that's one of the issues which has led to a number of cases where lots of evidence requires to be seen to show whether there's an implied consent or not. I think even globally, the first factor that always comes is the apparent agency, where, is there a principal-agent relationship? Very recently, I was doing a case and the counterparty cited a case where they said, oh, our director did not have authority to do this. And one of the issues that comes up very usually is that he is ostensibly the director of the company, and he's an agent, and basis that principal-agent relationship, this is an implied consent, and nobody can wriggle out of an arbitration agreement purely because they want to now say that he's not my agent. But I think agency law has, to some extent, been quite helpful in establishing implied consent. And many times, when we are trying to establish non-signatories, so to say, principal agent is one of the most common things that we see that gets agitated in courts. Another interesting aspect of principal agent, and keeping aside principal agent, sorry, for a minute, and just generally talking of what could be other factors of implied consent in India. One of the larger and a newer thing that came into India was assignment, and the assignment of contracts, does that lead to implied consent? Assignment, again, it's a contract law issue, and therefore it becomes very contract-centric, fact-centric as to what all clauses are assignable, what all clauses are not assignable. And therefore, lots of it is dependent on what terms of the contract are assignable, whether the arbitration agreement gets assigned or not. Sometimes it's also to do with how parties construct the assignment agreement, whether substantive rights along with the arbitration agreement rights get assigned or not. But there's been a lot of, again, agency for me is part A. It's the most important aspect where lots of cases around that has happened. But on assignment, implied consent is still sort of something which is in the gray, where people are still having enough room to argue from both sides. But one very interesting thing that has happened in India on assignment is, people have found ways under contracts to assign awards, to assign the benefits of awards. So it's an ever evolving concept on the issue of assignment. But, again, it does exist in terms of the implied consent part. And just quickly on the third part, which is estoppel, and I think that's the most talked about, and we'll probably in the next 1 hour talk a lot about it, is single economic unit, common, umbrella contracts, close connections. If these are factors which stops the parties, if sometimes there is a principal guarantor and there is a parent company subsidiary issue, can the parent wriggle out if they are guaranteeing something, if they are not signatories, but it's a common transaction where their role is enough to show that they have participated and they should be there in the arbitration. I think that's one of the reasons why Supreme Court has now kind of opened it up in that sense to in the Cox and Kings and refer this issue. And I hope that, when we do see arguments, and I'm sure it will happen, is these implied consent issues also become more crystallized. I think they exist. We all as lawyers know about them, we talk about them, but is there enough legal precedent in common law in India? The answer is yes and no, but no is something which it's more on something that we can do, less on what already exists. So I think it will be a good, it'll show us what the judicial precedents would look like once this is also brought in the new, in the constitutional bench.
Thanks, Ashish. Obviously, we're going to be talking a little bit about the whole evolution of law in India, and I'll get the others to chime in on that. Toby, disregarding of corporate personality, piercing of corporate veil, give the audience a sense when that comes into play in the context of extending the arbitration agreement to non-signatories.
So there are 3 categories of doctrine that are regularly used when you're trying to join a non-signatory, non-named party to an arbitration agreement. The first category we've already spoken about roughly, and those are the traditional contract doctrines of assignment and agency and novation and succession and trusts and various others. I'm not going to talk about those. The second category is to try and pierce the corporate veil. And that would depend upon the law governing the corporate veil. And there are doctrines of alter ego, there are doctrines of fraud, of abuse of a corporate veil. Not going to talk about those. The third category is much more interesting, and that's the controversial one. And that's the one that's live in India. And that is the so-called group of companies doctrine, one of the most described and least understood doctrines. And this is why. The group of companies doctrine began life in 1984 in one ICC case called Dow Chemicals and Isover Saint-Gobain. It's a very famous case and very, very much misunderstood. It was an ICC arbitration in France, French seat, governed by French law, with a very, very well-respected tribunal, Peter Sanders and Berthold Goldman amongst them, grandees of our field, governed by the ICC rules. Now, what happened in Dow Chemical was essentially 4 companies were on the plaintiff's side, and they concluded 2 contracts, and they mixed and matched throughout as to who was doing what amongst the 4 companies. It wasn't significant to them as to who signed the contract and who performed the contract and who terminated the contract. And what the ICC tribunal held, they said we should apply what they called general principles of international arbitration law. Quick footnote, what does that mean? International arbitration law is an odd concept because arbitration is a process. It's not a substantive law. Anyway, end of footnote. They're applying international arbitration principles and what they call trade usages. And on the basis of that, they found that the scope and effect of the arbitration agreement should be determined by reference to what they thought was the common intention of the parties. And in that particular case, the common intention of the parties was that the corporate veil did not matter, that all the 4 companies were actually bound by the arbitration agreement. And there was a notion there of single economic entity. Now, this is where things went horribly wrong. That award was challenged in the French courts. The Paris Court of Appeal upheld it. And they said that the intention common to all parties involved was that everybody, all the different corporate entities, would be bound. Then there were a spate of other French decisions supporting this. In notably 1986, a case called Sponsor and Lestrade, very famous case, frequently cited. And they held that a non-signatory had played an important role in the conclusion, non-performance, and termination of the contract, and so should be treated as bound by the arbitration agreement. And then things went mad in ICC arbitration over a period of years. ICC tribunals kept referring to this body of decisions, and built up, there was this something called ICC law. Second footnote. See the first footnote. What does that mean, ICC law? It's the end of the second footnote. ICC cases were coming out any number saying group of companies doctrine applies here. Again, what are we talking about in terms of the law here? That was then picked up by national courts with a varying reception. Generally, misunderstood and misquoted, if I may say with all due respect, by the Indian court in Chloro controls. The reception was a poor reception in most cases, in most countries, actually. And we can talk about that later. And that's where we get to on group of companies doctrine. And I think I'll pause at that point and we'll come back to have a look a bit more about some of the problems with it.
Yeah, superb. For some of you, when I put the next question to Toby, you will also understand when Toby is coming from and talking about group of companies doctrine. 2 of the leading cases globally in relation to joinder of non-signatories, this man here actually conducted the advocacy on it, amongst many other things. So I'm going to put you questions on that later. But this is a good segue to get Nish in. You know, one thing that I wanted to talk about, and it's very interesting. We just had a session before. We were talking about current challenges, and one of the things Mr. V.K. Raja spoke about, Justice Sanjay Kishan Kaul spoke about in the morning, was about arbitral institution and the role that they play, non-signatories to arbitration agreements, joinder of parties. And I think it is very interesting, and you know, again, I'll put this to Toby because there was one case that Toby did where SIAC 2007 rules were at play and there was an issue of joinder. But SIAC as an institution responded to public consultation and changed its rules. Nish, why don't you give the audience a sense on SIAC as an arbitral institution, how do they deal with you know, non-signatories and joinder of non-signatories?
Sure. I'll get happy to do that in the context of the latest rules. Rule 7 is the one that one would have to look at. You have 2 scenarios covered in Rule 7. The first is before the constitution of the tribunal, and second, after the tribunal is constituted. In the first instance, prior to the constitution of the tribunal, an application for joinder can be made, and it would go to the registrar and then on to the court, and the court would make a decision as to whether or not joinder is to take place. And thereafter, the tribunal can still consider, once appointed and formed, can still consider whether, as a matter of jurisdiction, that their jurisdiction is there in relation to all of the parties that are before them. The second is in relation to the situation where a tribunal has been constituted. The thing to bear in mind is the test is the same under Rule 7. And the test is essentially this. A party or a non-party to the arbitration may file an application to seek the joinder if the following criteria is satisfied. There are two criteria. Additional party to be joined is prima facie bound by the arbitration agreement, or all parties, including the additional party to be joined, have consented to the joinder of the additional party. So those are the two criteria, right? It's an or. So either the additional party to be joined is prima facie bound by the arbitration agreement, or all parties, including the additional party to be joined, has consented to the joinder of that party. Now, the controversy is usually around the first of the two and not the second. If all parties have consented to the joinder, then you have agreement of the parties, and that's not really problematic. But in relation to the first, which is the prima facie being bound by the arbitration agreement, a determination is made whether that additional party to be joined is prima facie bound by the arbitration agreement that the arbitration is concerned with. Now, I'm not going to deal with the application of that, but I think others are going to do that in a minute. And what prima facie means, what the threshold is for a prima facie determination of that sort is something that I'm sure we will address in due course.
Thanks, Nish. That's, essentially the prima facie standard does not say where and how it's going to be applied, and it's used to then bring into play implied consent, disregard of corporate personality, and whatever laws that apply to it. But if you're in the business of arbitral institutions, there's always competition between arbitral institutions. So SIAC has this standard of prima facie bound by the arbitration agreement. Other arbitral institutions have different standards. And how does that sort of play out in real life? And I think, Sui, and I wanted to ask you this question. There is a recent decision in Singapore that actually looked at a arbitration where the tribunal allowed a party which was governed by LCI rules. Why don't you give the audience a sense of that decision and also the distinction that's there, and honestly how that really impacted the parties' lives?
Thanks very much, Ankit, for that question. I think your question is directed at the CJD and CJE decision, which came from the Singapore High Court, which is a Justice Mohan decision. What is very important about this case is as follows. It was a situation where there were various parties who were all parties to a joint venture agreement. There was an arbitration clause, and the arbitration is governed by the LCIA rules. The arbitration was commenced by one of the parties, CJD, against CJE. The arbitration was ongoing, and then CJD decided to make an application to join one of the other parties to the joint venture agreement to the ongoing arbitration. The question then came up for interpretation by the tribunal as to, does the tribunal, in the course of the arbitration, have the power to join one of the parties to the JV agreement, which contains an arbitration agreement, to this arbitration that's already ongoing between CJD and CJE. And what they had to then interpret was a very precise provision of the LCIA rules, which says that the tribunal shall have the power, upon the application of one party, to allow one or more third persons to be joined in the arbitration as a party, provided that any such third person and the applicant party have consented to such joinder in writing. And this is either following the commencement date or earlier in the arbitration. I then asked you in the audience, if you were the tribunal who has to decide this question of jurisdiction, how would you decide this? Let's bear in mind that the party that's seeking to be joined is actually a party to the joint venture agreement. The party that's seeking to be joined is a party to, in a sense, that arbitration agreement, which is part of that joint venture agreement, of course, bearing in mind the doctrine of separability. So the question is, just by the mere fact of this third party being a party to a joint venture agreement that has the arbitration clause, does that constitute consent in writing to be bound? And Justice Mohan, in what I would say, a very well-reasoned decision, which really premised the entire concept and the entire decision on the importance of party consent to international arbitration, said No, that is not sufficient. And why is it that it is not sufficient? Justice Mohan said that how could it be that this third party, albeit being a party to a joint venture agreement that has an arbitration clause, be left in this limbo and in this uncertain position where at any point in time, whether before, after, in the midst of that arbitration, without having any say in the constitution of the tribunal, could somehow be compelled in a forced joinder situation to then be part of this arbitration. So he found that that very fact that it is a party to the joint venture agreement, that in itself was not sufficient to constitute consent in writing. And this, I feel, is an extremely well-reasoned decision, because how could you be then compelled to be forced to be part of this arbitration agreement, bearing in mind the fundamental bedrock of party consent? And of course, he also said the double separability principle, which is that one must understand that this is an ongoing arbitration. So that makes it even more harder and more difficult to join the third party. I just want to add one more point. One do wonder whether, if we were looking at the SIAC rules, where the standard is simply prima facie bound by the arbitration agreement, perhaps a different decision would be reached by Justice Mohan, because that very threshold of prima facie bound by the arbitration agreement is very much more lax, which I then do say as users, as lawyers, when we advise our clients on the appropriate rules to apply, must be very clear in our mind as to the different standards in the institutional rules and choose the right rules. Nish, perhaps you wish to add something on that.
No, totally agree, Suen. I mean, this was a case that was decided in Singapore by a Singapore judge, but it didn't involve the SIAC rules. It involved the ICC, I beg your pardon, the LCIA rules, which has now, at least, a requirement for express consent. And that was the context in which Justice Mohan made those comments. Whereas if you look at the language in the SIAC rules, you're talking about prima facie bound by the arbitration agreement. On the facts of that case, it's not prima facie. That third party was a party to the joint venture agreement in which the arbitration agreement was contained. So would the same decision have been made if it was under the SIAC rules? Perhaps not. And that goes to Suyen's point. I think it's quite important to understand the nuances and to understand what tools you want for your dispute resolution process, including the arbitral institution and the rules that institution has.
Yeah, thanks, Nish. Thanks, Suyen. I think this is critical, because the choice when you make of putting in an arbitral institution in your arbitration clause, you don't realize the impact that it has on the entire process of arbitration. I think that's a perfect example of discussing this issue of joinder of non-signatories in the context of arbitral institution. But in reality, as we've discussed, a lot of the arbitrations in India, I mean, come for a conference 15 years ago, it was much more topical to talk about ad hoc versus institutional. I'd hope that it's less so in India. But what I want to do now is want to ask you, Aseem, to sort of give us a complete overview, brief, quick overview of the legal position in India in relation to joinder of non-signatories, non-signatory to arbitration agreement. Just give us a sense, give the audience a sense of what the law has been, how it's sort of developed, because we'll then dive into a little bit. I know Chloro controls has been referred a few times. We'll dive into that soon after. But why don't you do that first?
Thanks so much, Ankit, for that. So the journey of non-signatories and the group of companies doctrine in the past 2 decades. I'll talk about the first decade and I'll try and sum it up in 9 judgments, which are landmark in, so to say, in this area. The first judgment in which the non-signatories and group of companies was briefly discussed was Sukanya Holdings, wherein in a suit, non-signatories were brought in, and the Supreme Court held that until and unless there is a written agreement between the parties, they cannot be referred. It's either consent or a written agreement between the parties. Then the Delhi High Court was faced with a judgment in KK Modi versus Apollo, wherein the Delhi High Court was of the view that the Indian Companies Act, there is a doctrine of independent juristic legal entities. All companies are different, so therefore an act of one company, the other cannot be bound by it, and therefore non-signatories were not allowed to be brought into an arbitration. This is 2009. 2010 was Indocare versus Westwind, wherein the Supreme Court, following what the Delhi High Court did, went a step ahead and said not only will non-signatories not be bound by an arbitration agreement irrespective of a single economic entity, even if there is common shareholding, common directorship, even then you cannot bring those companies into arbitration until and unless they have an implied or an express consent to go into arbitration. Now the last decade, things have been very different, and especially with Chloro control being the landmark judgment where this doctrine was first time recognized, and we were representing one of the parties there, and I think I can talk till tomorrow on how Chloro control went. But what I like to just anecdotally share that, you know, the matter went on for about 4 weeks, Tuesdays to Thursdays being spent in the Supreme Court, our living legend Mr. Nariman on one side and us and Mr. Salvi on the other side. But that really laid the foundation of what the group of companies doctrine and how non-signatories can be brought into the realm of arbitration. This was the first shift in the last decade from this decade on the group of companies doctrine. Then the law has evolved much further, and the Supreme Court has given a purposeful interpretation to this whole concept. And the shift has been to try and bring in group of companies doctrine where there is either a single economic entity or the agreement in itself was so intrinsically interlinked that the non-signatory has to be either deriving benefit or was deriving benefit of that agreement. So we saw Amit Lalchand, which is a 2018 judgment of the Supreme Court, wherein the Supreme Court said that if different agreements are drawing strength from a parent agreement, then even those signatories can be brought into the realm of an arbitration. In Charan Properties, which was about a month later from Amit Lalchand in 2018, the Supreme Court went a step ahead and not only brought a non-signatory in what we were discussing is, can non-signatories be brought into an arbitration proceeding? Supreme Court in Charan Properties went a step ahead and said even in execution proceedings, you may not have participated in the arbitration process, but if you were deriving benefit from that award, or you knew that those proceedings will affect a non-signatory, even non-signatory can be brought into the scope in an execution proceeding as well. Then came in MTNL versus Canara Bank, wherein the Supreme Court went a step ahead and said that, you know, if you have participated or you were negotiating the contract, or if there is an implied consent by conduct, even then a non-signatory can be brought into the realm of an arbitration process, and this is 2020. This year we have seen 2 judgments, and the first being ONGC versus Discovery Enterprises, wherein again we were on the suffering end, unfortunately, and I not want to talk about a matter where we were involved, but the Supreme Court in April of 2022, a 3-judge bench held that there are 5 tests really which need to be seen if you're looking at non-signatories and group of company doctrine, that if there has been an intrinsic involvement in the contract, or there is a parent contract, or there is an implied consent, in those kind of cases you can bring in group companies and non-signatories into the scope of an arbitration. 1 week later, a 3-judge bench of the Supreme Court led by the Honorable Chief Justice of India back then has, in Cox and Kings, referred the entire concept to a larger bench. 6 questions of law have been framed, and let's hope as soon as possible we get clarity on this issue. So that's been the journey of the group of companies doctrine in the last 2 decades.
That is one hell of a fascinating journey. I must say, you know, and we'll talk about Singapore and we'll briefly talk about UK as well, but I think one jurisdiction that has really taken to this topic of non-signatories is India, and, you know, come out with so many decisions. But I think everything sort of boils down, the tipping point, Shujo, was the Chloro Controls decision. I think a lot of us would benefit, and I know Swegan has some very strong views, and I know Mr. V.K. Raja spoke about as well that he doesn't agree with what the court said. But why don't you give the audience, give all of us a sense of what were the principles that were really laid down in Chloro Controls and how that has sort of influenced parties' lives in arbitration?
I'll start by asking a rhetorical question. Why do we still refer to Chloro Control almost a decade after the judgment was passed and a lot of water has flown under the bridge? If you actually look at the opening line of the judgment, Justice Swatandra Kumar makes a remark saying that we've actually reached a place where we need to re-evaluate the law on arbitration and bring it up to date with the jurisprudence which is prevailing internationally. So that is his opening comment. Now after that, and my co-panelist here mentioned that we had the best of opposing counsel bringing in different perspectives to the matter. So we had Mr. Nariman trying to get the appeal admitted, and there was Mr. Salve on the other side. And one very compelling argument that he made was that, look, we have the Civil Procedure Code. And if you look at Section 9 of the Civil Procedure Code, it gives almost unlimited jurisdiction to the parties and for the court to hear matters. So why do we have a situation where, by virtue of an arbitration, you need to take this jurisdiction away? And there, after evaluating all the pros and cons, the court went on to observe a few things. One was that if you look at what the 1940 Act was, which is, before we adopted the ancestral model and the 1996 Act came in, there, under the 1940 Act, it was permissible to refer only some of the parties or a part of the cause of action to arbitration. But that power was no longer there once we transitioned to the 1996 model. And this was specifically done to cover up all the loopholes which were there. For those of you who are familiar with the Indian law, we not only had a 1940 Act, but we also had the Foreign Awards Recognition Act, which was played in tandem. And really, this was to take the whole proposition one notch ahead. There was an inherent need to have the law consolidated. Now, Sukanya Holdings, of course, we talk about quite a bit, but in Chloro Control, the court went on to say that Sukanya is really on a limited perspective, which would possibly be more appropriate in a Section 8 scenario. And there again, that was the unamended Section 8 as it stood then. But clearly, the language of Section 45 and the high impetus which is there to relegate the parties to arbitration, that is completely at a different pedestal. And keeping this in mind, the court went on to evaluate the group of companies doctrine, its evolution in English law. It even went on to refer to commentaries of Mustill and Garibaldi and some of these celebrated commentators, and finally came to the conclusion that we now need to move in tandem with what is happening in common law jurisdictions and recognize that this is really the time that we need to move on.
Superb, Shujo. Did you have a comment to make, Toby, now? Okay, go ahead. Why don't you make the comment?
No, I'm just going to say that's one of the big errors, with all due respect, is to say we take on board what's happened in common law and we're now going to manifest that in Indian law, because it was a misunderstanding of what's happening in common law. But I will elaborate if you want me, but I'm in your hands.
No, okay, I'll come back to you. I'll come back to you on that. What I want to do, and I know there are eager panelists who want to talk about Chloro controls. I'm thankful that Justice Sutanta Kumar is not in the audience. But Sri, and why don't you go ahead and quickly and perhaps briefly just talk about your brief views on Chloro controls and then compare that with the position in Singapore. We've got the Mantra Steel decision. But very briefly, why don't you go ahead and do that?
You see, to me, I entirely echo Toby's words when he says Dow Chemicals is misunderstood and misapplied. I am also of the view that Chloro controls is misunderstood and misapplied. Interestingly, Surya started off by saying, in Chloro controls, they said, we are following jurisprudence that is international. But is there indeed jurisprudence that is international? Is there indeed what in Dow Chemicals they say is international trade usage? There is not. In this pursuit for love of international arbitration, have we compromised on what are true legal principles? Have we compromised on the fundamental bedrock of arbitration, that of party consent? So to me, the only way you could join anyone to arbitration is if you find that party consent. And party consent is critical because let's not forget, when a party decides to go to international arbitration, he, she, it is giving up that right to go to court. He, she, it is giving the arbitral tribunals that power, that legitimacy to give an award that is final and binding, that is not subject to challenge on the merits, that is enforceable in over 160 countries. That is an extremely powerful power that you're giving to the tribunals. And to take away that right from a party, it is critical for there to be party consent. So I do not believe in there being a separate doctrinal basis known as group of companies doctrine, where just simply because of the fact that there's a parent, there's a subsidiary, the parent was involved in the negotiation, execution, performance of the contract, that the parent is not a signatory to that arbitration agreement or that contract, that somehow the parent is found to be a party because of this clear and mutual intention to be bound. And just let me touch on the Singapore position in case there's any misunderstanding as to this being the Commonwealth position. In Singapore, we do not recognize a group of companies doctrine. We do not recognize a single economic entity doctrine. We respect separate legal entities. The fact that you have consolidated accounts, the fact that you are part of a group, does not then somehow translate into consent to be bound to arbitration.
Yep.
Toby
Thanks.
will
Yes.
continue
Yeah.
to elaborate on that, I'm sure.
I mean, one has to say that there is some sympathy with the Supreme Court. Look, at the end of the day, you're trying to balance two things. You're trying to balance this desire to keep the arbitration to, between two consenting parties. But at the other end, there are commercial realities which are slightly different. And that's really what the Supreme Court was doing. But I think, why don't we quickly get Toby, quick views on something that Shurja and Swayan said, and perhaps very briefly, do the UK courts agree with that sort of thing? And,
So the last point first, no. As to the other points, I just want to explain very briefly, I'm going to do it in 4 points, what the misunderstandings are about group of companies doctrine. All right? Point number 1, where group of companies doctrine comes from is the French approach to governing law. In France, they have done away with conflict of laws analysis for arbitration agreements, international arbitration agreements. They treat them as transnational autonomous contracts. And that means they're not actually subject to any municipal national law. They are approached just from a factual basis in terms of consent. And that explains Dow Chemical, which was a French case governed by French law, then with an application before the French courts. So that means you do not look at substantive law principles of, for example, the corporate veil. And that's why it's got no application at all to every other system, including India, that doesn't have an autonomous concept of arbitration agreements. Point number 2. This is my understanding, in Chloro controls, they put emphasis on the words a party claiming through or under, which appears in a number of places in your statute, and it appears in many statutes in common law countries. Group of companies doctrine doesn't match that phrase, because that phrase is about derivative rights. Claiming through or under a party means you're not claiming in your own right. You're claiming in the right of the other party through which you're claiming, you're acting. That's not group of companies. Group of companies says you claim in your own right. And therefore, that's the mismatch here. It's actually got nothing to do with those words. Point number 3. Actually, group of companies, when it's properly understood, is not about consent. It's about estoppel. This has always been explained by Otto Sandrock when he was condemning the analysis of the UK Supreme Court in the Dalla case, where they analysed French law and came to a conclusion. Shortly afterwards, the French court had unusual delight in concluding that the UK Supreme Court had misunderstood French law and disagreed with them. It's not actually about do you consent. The facts in all these cases are about equitable estoppel. That means you have acted in such a way that you can no longer deny that you are a party, even though the language of the text isn't always that clear. And the last point, and then I will stop. This is a confusion of procedure and substance. It doesn't make sense to say I have chosen ICC arbitration and therefore I have bought into other ICC decisions on procedural issues, because it's a process, it's not a substance. And so how can you then say, actually you're bound by something called ICC law? There is no ICC law. You're bound by the governing law of your agreement unless you are in France.
Thank you. Thanks, Toby. the issue of joinder or extension of arbitration agreements to non-signatories comes up at different stages. You know, we briefly discussed coming up before the commencement of arbitration, somebody files a civil suit and then that question comes up, or you go for appointment of arbitrator. Nish, Swian spoke about the SIAC rules and how the SIAC got initially, but the tribunal will look at it when the arbitration is going on. But I think one of the things that's extremely interesting to also talk about is once the award is rendered and then you go in for enforcement. So what I'm going to do very quickly, Ashish, get you to talk about this one decision that came in relation to where in the arbitration there was a non-signatory that was allowed to be put in. What did the Supreme Court say on that? And then I'll get others to talk about that as well.
I think, given what we've heard, the latest decision of the Supreme Court in the Gemini Bay transaction may perhaps not be liked on the right side of the panel, because, you know, the thing is, the Supreme Court took a more pro-enforcement view, and they said, we don't care whether they are signatories or they're not. The question is, there's an arbitration award, and that arbitration award has to be enforced. And if we looked at Part 2 of the Arbitration Act in India, it does not give any indication of whether they are signatories or not. It talks about an award being there and to be enforced. And I think, to some extent, if we are in a regime where we are looking at non-signatories being bound in an arbitration, then perhaps the necessary corollary to that is that the enforcement should happen. Either the regime changes to an extent where non-signatories are not allowed to be there in the arbitration agreement, but in the current scenario, it was, in my personal view, a decision that was welcomed, because it also indicated the pro-enforcement approach of the Supreme Court. And I think that has been the talk of the town for a long time about Indian courts and how they're enforcing foreign awards. And I think this just reinforced the fact that in the Supreme Court looked at it and said, look, we need to have a pro-enforcement approach. And just quickly, you know, it's a recent judgment, so we don't really know the practical implications of it. I think the law is laid down in that sense, and now that we have the Cox and Kings, I don't know if this would be touched upon, but I believe that if eventually these non-signatories becomes something that could come under an objection that can be raised for enforcement of a foreign award, then perhaps the whole regime changes. So I believe if the regime stays, the enforcement needs to stay. But if the regime changes on the other side, then perhaps this changes with it.
Fascinating. This is a situation where the Indian court actually said, you know what, pro-enforcement, I'm going to go ahead and enforce it. Whatever happened in the arbitration, this is what it is. But you know what? Dobie did two matters in which there were arbitrations that were conducted. There was a seat of the arbitration. While the courts at the seat were looking at the issue of setting aside of the arbitral award, the award came up for enforcement in other places. And the courts of the enforcement were applying the law of the seat, which was the governing law. What happens, Toby, when you've got these parallel issues? You've got courts of the seat, you've got courts of the enforcement. What happened? What happened in Dalla? What happened in Astro? Both of the cases in which you were able to successfully resist enforcement.
Yeah, I should say I'm developing a niche practice of non-enforcement of arbitration awards. So in both the Dalla case in the UK Supreme Court and in the Astro case, which went up to the Singapore Court of Appeal, and it also went up to the Hong Kong Court of Final Appeal, awards were not enforced. And the reason for that was because under each case, under the New York Convention, Article 5, the objection was made that the parties who had been found by the tribunal to be parties were not in fact consenting parties. And that means that under most systems, the court who is being asked that question will apply a de novo analysis. That means they will start again on the question of jurisdiction and rehear it. And that means not necessarily giving deference to the tribunal's analysis because of the law of physics. and that is, and you can try this in your own time, you can't pull yourself up by your own bootstraps, your own shoelaces. And so even if the tribunal says they have jurisdiction, if in fact they are not a tribunal, in truth, they can't have the final say. What that means in practice is that you get a full rehearing in court. And that rehearing could be totally different from the nature of the hearing you had before the tribunal. And so just to bring this in full circle, in the Dalla case, there was a group of companies analysis that happened by the tribunal. And when that got to the Supreme Court took a completely different approach.
Yes, yes. I think, Ashish, you mentioned about Cox and Kings. All I can say is that the uncertainty and the contours of this non-signatory to arbitration agreements and its treatment by courts is going to remain inconsistent, but that also means that us as arbitration practitioners and lawyers will continue to be busy. But what we want to walk away from over here in this session is we want to give some practical pointers and tips to people attending, you know, who are doing SIAC arbitrations. A couple of quick questions to some of the panelists. I want to talk about practical considerations. Let's talk about it from the tribunal's perspective. Nish, you sit in arbitrations, you sit as an arbitrator in multiple arbitrations. As an arbitrator, when you are dealing with an application for joinder of a non-signatory or the issue of non-signatory to an arbitration agreement comes up, of course, you know, you're conscious of the fact that it will go on for enforcement, law, but what are the views, what are the practical considerations that you want to throw some light on?
Tribunal's perspective. More parties, more fees. Isn't that the perspective? No, in all seriousness, look, most tribunals will look at the issue very, very carefully for exactly the reasons that you highlighted, right? Tribunals will want a fair and efficient process, for sure, an expeditious process, sure. Would want all relevant parties before it so that the issues can be determined in the round. And would also, I think, be careful not to allow parties should otherwise not be there to be there. What that will involve is an analysis of the application that's made, will have to involve the rules, if there are rules that would otherwise apply, and a determination has to be made dealing with the principles that we've been discussing right through this afternoon. And a decision is then made as to who the appropriate parties would be for that particular tribunal to decide. So I think it's quite a careful analysis that most responsible tribunals will spend a lot of time on and hopefully arrive at the right result on.
So that's a pointer to all the parties in which Nish is sitting as an arbitrator. So just be careful. This is how he's going to assess it. This is how he's going to analyze it. And I think that's the fair approach. Last question. I would have ideally wanted to invite questions from the audience, but we are catching up on time from the earlier session, so we're going to do justice to Shweta and the team and wrap up slightly earlier than we had anticipated. Swiyan, very briefly, what if you are a non-signatory who's trying to avoid this whole process of arbitration, trying to run away from it? Any practical tips, any pointers? I'd imagine a lot of those could be Indian parties as well, so any practical tips, very briefly.
Okay. In view of the differences in joinder provisions in institutional rules, as we've just heard, SIAC, LCIA, in view of the misunderstood, misapplied Dow chemicals and Chloro controls, as I say, I think it is important not to just follow the model clauses of institution anymore. I think we need to specifically specify this arbitration agreement is only binding on the signatories to this contract and not binding on any other party, not any related company, and not any group company. That's what we should do moving forward.
Sweet, and remember, your next brief is going to be one where you're trying to get a non-signatory in. So better make sure that your corporate colleagues leave it open enough for all of us. Anyways, thank you so much for being patient and listening to all of us. Please join me in thanking the panelists. Please, thank you so much.